Hello, everyone. My name is Victor Manibo. I'm a senior attorney here at Wang Law Office. You are watching the AM show, our question and answer immigration show.
Hi, my name is Ariel. I'm the host, also a senior paralegal at Wang Law Office. Our show going to start every Friday at 11 a.m. EST, 8 a.m. PST.
Here at the AM show, we try to answer all your burning immigration questions. We encourage you to send any questions that you have through Line or YouTube or email, and we'll gather them all in one episode. And, we talk about a certain topic each episode. Now, for this week, I thought it would be a good idea, because we're at the end of the year, to talk about the questions regarding new policies that came out in 2022. So that's what we'll be talking about today.
Victor, before we start talk about those topics, can you introduce a little bit on your own background?
Sure. For those who haven't met me yet, again, my name is Victor Manibo. I'm a senior attorney here at Wang Law Office. I've been with the firm for 10 years, and I've also been an attorney for 12 years. I graduated from Cardozo School of Law here in New York, and I'm licensed to practice in New York and New Jersey. Now, here at Wang Law Office, most of what I do is immigration litigation, meaning I help people in immigration court and defend them from being removed by ICE. I also do a little bit of immigration applications, meaning filing status applications with USCIS to help non-citizens gain lawful status here in the country. Aside from lawyering, I'm also a published author. I write science fiction and fantasy books, and I just published The Sleepless back in August.
So, Victor, what are some of the major changes in the immigration code?
So in this past year, there are a couple of changes in immigration court that we saw, and they're mostly for the better. The first one is ECAS. This is the EOIR Courts and Appeal System, which is now available in all immigration courts and the BIA. It only became fully available and operational in February of this year, and now its use is mandatory in all immigration court and BIA cases. It allows attorneys and respondents or non-citizens to electronically file their documents with the court system, with our immigration court system.
So what is this ECAS system?
So this system, like I said, is an electronic filing system. It's part of an overarching information technology overhaul of the EOIR. We keep talking about backlogs in immigration court, and most of that backlog is because of because a large part of the court system isn't electronic yet or isn't automated yet. So ECAS is this new e-filing system that allows everyone to just transact their court business electronically. It was first introduced in 2018, and it was kind of like done in a pilot program in certain parts of the immigration court system, and it's taken a few years before it's been adopted this year to all the immigration courts and the BIA. So now it's available everywhere. We're going to provide a link on this video so that people can check out what ECAS is and see what the frequently asked questions are about ECAS. But basically, that's what it is. It's an electronic filing system.
So use this ECAS system will be good or bad?
Well, generally, it's good, because most people, not just in courts, but in any part of life, everything is transacted electronically. You email things, or everything is done through a website or an app, right? And the ECAS system is a court filing system that's fairly secure and fairly fast, and it will allow you or your attorney to submit and file documents or motions with the court. You can file an appeal if you lose your immigration court case. You can file an appeal electronically also, and you can also get a copy of your records from EOIR, from the immigration court system, or from the BIA. What that means is you don't have to mail things. Nothing gets lost in the mail. You don't have to wait a long time to get a receipt or to get the records that you're looking for. So everything just becomes faster and more efficient, and obviously it's also more environmentally friendly, because it's going to be drastically reducing the use of paper within our huge immigration system.
Yes, the immigration court actually changed a lot, and then those new rule is common. You and your lawyer need to know how to do it and then get used to it.
Yes.
And there's also some good news about immigration court this year, right? There is a new law about immigration judge and then the BIA authority to terminate a case.
Yeah, that's correct. So just a few weeks ago, we talked about this. Ms. Wang told you about a matter of Coronado Acevedo, which is a BIA case that restores the rights of an immigration judge or the Board of Immigration Appeals to terminate a case, to basically end an immigration court case. In the past few years, that power to terminate has been taken away by the former administration, by the Trump administration. Basically, they said immigration judges cannot just terminate a case. They have to basically finish everything. But there are good reasons why an immigration judge or the BIA might terminate a case. And so this new case, matter of Coronado Acevedo, gives that power back to the IJs and the BIA. The Biden administration is basically saying IJs and BIAs have this power once again that they've always had, except during the Trump years.
So what kind of situation I can actually ask that termination?
So under the terms of matter of Coronado Acevedo, there are 3 situations where someone can seek termination. One is if they've already obtained lawful permanent residence status, meaning they're already a green card holder. If they happen to be still in proceedings for some reason, then they can ask for termination. The second is if the removal proceedings is preventing someone from traveling abroad to obtain an immigrant visa. This is specifically for people who are thinking of doing the I-601A provisional unlawful presence waiver, where, we talked about this in a previous episode, where you can leave the country to finish your consular processing, but do all the waivers, do all the petitions while you're still in the United States. For I-601A folks who want to do that, if you have removal proceedings pending or a removal order, you can't just leave like that easily. It's kind of complicated. Now, if an IJ terminates your case, then you can. So under matter of Coronado Acevedo, you can ask for termination so that you can do 601A and leave the country so you can do your consular processing in your home country. And third, under matter of Coronado, you can ask for termination if termination means you will be allowed to seek relief with USCIS. And relief is a very general term, but a lot of the people who can benefit from this are people who have maybe family-based petitions or employment-based petitions who are in immigration proceedings and cannot file their adjustment of status or green card applications with USCIS because of immigration court proceedings or BIA proceedings. In the past, if you have an immigration court case or BIA case, even if you have an approved petition for you, you can't ask the judge to terminate the case so you can file a green card. Now, because of this new case, matter of Coronado, you can ask the IJ, say, hi, judge, I have an approved petition from my US citizen wife. Can we terminate the case so I can apply for a green card with USCIS? Now, because of this case, you can do that.
So you mentioned 3 kinds of people, right? Is the termination only limited to those situations?
Well, for now, under the terms of that case, those are the only situations, but there are always new situations. As I mentioned, the Biden administration is doing a lot of things, a lot of changes that are more positive. So in the future, pending new rulemaking processes, there might be other situations that will allow people to ask for termination and not just those 3.
So can the immigration judge or the BIA terminate my case even I already have a deportation order?
Yes, so it's not just for people with pending immigration proceedings. If you already have a deportation order or a removal order under Coronado Acevedo, you can also ask to reopen and terminate your case if you fit in one of those criteria.
What if I don't have the I-94? Can I still ask the IJ or BIA to terminate my case?
So the I-94 is a proof of admission, and that's relevant for adjustment of status generally, so that you can get LPR status. However, for some people who might be able to get LPR status but don't have an I-94, the path for them is the I-601A process, where they have to leave the country and finish consular processing in their country of origin. And like I said, under matter of Coronado Acevedo, you can ask to terminate if you want to do 601A. And these are the people who do not have an I-94 generally. So the quick answer to your question is, yeah, even if you don't have an I-94, if you are doing I-601A, then yes, you can ask the IJ to terminate your case so you can do I-601A and do that to completion.
So is the termination the only option I can have to get rid of removal order?
We've talked about getting rid of removal orders in a previous episode. One of the other ways that people usually think of in trying to get rid of their removal order is the use of prosecutorial discretion or talking to ICE to maybe work out a deal. That helps a lot of people, and until recently it was effective. However, prosecutorial discretion has been temporarily stayed by a court order, so that's not necessarily a good option for now. Right now, termination, really, if you fit into one of those criteria, that's really the best option to get rid of your order.
Yeah, if you want to know more information about this termination, you should look at our prior YouTube, and then you can see if you can do it. But most importantly, you can call in to see if you qualify for it.
Yes.
So I know that there is also new on the IEP, right? What is IEP?
Yeah, before we start, IEP has had an update this year, but to refresh our viewers, IEP is the International Entrepreneur Parole Rule. I'm sorry. And it's where DHS or ICE uses its parole authority to let certain business persons in the country and let them stay here on a case-by-case basis if they can show that staying in the United States would provide a significant public benefit through a business that they own. Usually these are startups. So if you are a business person, you have a startup in the United States, you might be eligible for IEP.
So who actually eligible? What are the requirements for IEP?
If you are thinking of IEP, you have to meet certain criteria. First, you have to have a central and active role in a US-based startup that's been created in the last 5 years. So we're talking about new businesses. If you have a central role, meaning you own the business or you're in a high management position. Second, you have to possess at least 10% ownership stake in that business. So you might not be the full owner, but if you own at least 10%, then you are eligible for IEP. And finally, you have to show that you've gotten, or the business has received, substantial investments or government grants or government awards, meaning other entities, not just you and not just your co-owners in the business, but outsiders have put in money in this startup to show that this startup is viable, that it has a potential to succeed, even though it's just new.
So any change after the IEP is bad for the requirement?
Yes, so this year, the new rules for IEP is that they changed the amounts that are required for the qualifying investments or qualifying government grants and awards. Now, I mentioned earlier, the third qualification is that you have to show that other investors or the government has put money into this business. The USCIS recently came out with rules as to how much money this is supposed to be. And so that's what the new rule is about with IEP. Right now, you have to show a minimum of 264,000, about that amount of qualified investments, and about 105,000 for qualified government grants and awards. If you don't meet those numbers, you can partially meet them, but also provide extra evidence that shows that even though you don't meet those numbers exactly or you don't exceed them, there are other signs that the business is viable, that the business can grow and provide a public benefit to the United States.
So we're talking about investment, right? Can my US citizen relative be the investor?
This is a common question we get about IEP. You know, if you have a business, can your maybe sister or brother or uncle invest in the company and so that you can meet that minimum of 264,000 qualified investment requirement? And the answer is it depends. It can't just be any relative. You have to show that your relative regularly invests in startups, regularly invests in business. So it's not that your uncle is just giving you money for your business because he's your uncle, but this is something that your uncle regularly does, invest in other startups, right? Your relative has to show that in the last 5 years, they've given a certain amount to other startups. And also, you have to show that your relative has invested in businesses that have actually grown. These businesses that let's say your uncle invested in, put money in, these businesses actually had signs of growth, like they created jobs or generated a certain amount of revenue or returned the investment of the investor up to a particular percentage. So again, all of these requirements are supposed to show that your relative isn't just giving you special treatment and giving you money and an investment. It's that this relative regularly does this and is actually good at it because he or she is giving money to businesses that tend to succeed.
So how about the government grant that you just mentioned? What is that?
So the government grant, it's basically free money. The government sometimes gives money directly to businesses to help them for economic development, for research and development, to create jobs. And if the government, a state, local, or federal government gives your business money, that's called a grant or that's called an award. And if you get that kind of money within 18 months of filing an IEP application, and if you meet the amount of around 105,000, then that's going to help you qualify for IEP.
So if I only meet part of the requirement, what to do?
Right, so those numbers that I mentioned are new and they're important. You have to hit them or exceed them. You have to show that there's this much money or more that came from outside investors or from the government. But if your business is lower than those amounts, you might be able to convince USCIS to still approve you for IEP, but you have to provide additional reliable and compelling evidence that your startup business, even though it's new, it has a substantial potential for rapid growth, meaning it's going to make a lot of money for you, it's going to pay a lot of taxes to the government, it's going to provide a lot of jobs for the area where it's located, and those that evidence and proof, that differs, but it's mostly going to be financial documents. And if you have those financial documents, projections, and reports, then you might be able to qualify for IEP, even if we don't meet those new numbers.
Yes. So if you want to learn more about IEP, you can go back to our prior YouTube on this, or you can call in to consult to see if you can do it. Victor, I know that there's also new update on SIJS this year, right? But first, what is SIJS?
All right, so SIJS is Special Immigrant Juvenile Status, and this is a special status that is provided to some children who are present in the United States who don't have status but need humanitarian protection because they've been abused or neglected or abandoned by their parents. This status has been around for a while, but there's new rules about it that was just implemented this year.
So this SIJS can help me to get a green card, right?
Well, it's a path to a green card. It's directly aligned to getting LPR status. So it's an immigrant classification that allows these, like I said, vulnerable children to get LPR status right away.
So who eligible for SIJS?
So if you're a child, meaning under 21 years of age, and are unmarried and are physically present in the United States, you can get SIJS if you can show that a juvenile court has ordered and found you to have been abandoned, abused, and neglected and in need of protection. That court order is something that we talked about in a previous episode, specifically with SIJS. But that's basically the most critical piece of the qualifications. If you're under 21 in the United States, no status, if you can get that court order, then you have a very good shot at getting SIJS.
So what are the change on the SIJS?
So one of the major changes about SIJS is about aging out. We talk about backlogs all the time on this show, and a lot of people, they file an application and then they grow up because time passes. They become a certain age and they're no longer eligible for the relief that they applied for. That was a risk with SIJS because it's required that you have to be under 21. And in the past, if you are over 21 when the SIJS application is decided, then you're no longer eligible. Now, the new rule says it doesn't matter if you become over 21 while the SIJS application is pending, as long as you filed the application before turning 21, then you are protected. You will not age out. So that's one major change that's going to help a lot of applicants for SIJS. There are also a few changes, and they're a little too numerous, but there are a few changes that will allow more applicants to qualify for SIJS in an easier way. There's also changes that will prevent requirements where a juvenile victim has to contact their abusive parents in order to get the court order. This is, in the past, a child or a child's relative might have to do that in order to get a court order. They had to communicate with the parent or, a parent who has been abusive or abandoned them or neglected them. This is no longer a requirement. They cannot be required. Now, SIJS applicants cannot be required to do that anymore. So again, all these changes, because of the Biden administration, are all meant to make it easier and safer for non-citizens to apply for status, and that includes these very vulnerable children. Now they don't age out. Now they don't have to contact their horrible parents, and now it's easier for them to apply for SIJS.
Yes, if you yourself or your relative might qualify for SIJS, you should call in for appointment to see if you can do it. Then finally, I see that there is some positive change on DACA, right? But before we talk about those change, what is DACA?
So DACA stands for Deferred Action for Childhood Arrivals. This is a law that's been around since 2012, and it was intended to protect people who came into the United States as children and do not have legal immigration status. If you meet certain criteria, you can get deferred action, even though you don't have status if you came in here as a child.
So what is deferred action?
Deferred action is the use of prosecutorial discretion by ICE, where they choose not to remove someone from the country, even though that person does not have status. And usually, ICE is going to say, okay, you have deferred action for a particular period of time, meaning for this period of time, we're not going to kick you out of the country. For DACA, it's a period of 2 years. ICE is saying, essentially, if they grant you DACA, for the next 2 years, we are not going to try and remove you. Plus, during this period, you are allowed to work. You are eligible to get an employment authorization document or an EAD card or a work permit.
I heard there is a new rule for those DACA, right?
Yeah, so this year there was a new rule that was publicized in August, and it became effective in October, so just a few months ago. And it basically makes it easier for a lot more people to apply for DACA. You see a pattern, right? Like all of these changes are for the better, like I was saying. So the changes to DACA is also about that, particularly about the age of the people who are qualified to get DACA.
Can you give me more detail about this new final change?
Right. So let's talk about the qualifications for DACA. You have to have come into the United States before you turn 16 years old. Like I said, DACA is for people who arrived here as children. And you have to show that you continuously resided in the United States from June 2007 up until the time you filed for DACA. So these are for people who arrived here as children and who have been here for quite a long time, right? Since 2007. You also have to show that you have been in the United States since 2012, because that's when the DACA rule came in effect. And that's going to be easy to show. If you've been here since 2007, then obviously you're also here in 2012, right? Except for like certain situations where maybe somebody left or, something happened, right? And obviously, if you have to show that you don't have status, because you wouldn't apply for DACA if you already have status. And you have to show that you graduated from school, or you have a GED, or you served in the military and was honorably discharged. And finally, you have to show that you don't have any serious criminal history. Now, aside from all of those, because that's old news, like that's been the DACA requirement since 2012. The new rule now that kind of expands DACA is you can get DACA if you're born on or after June 16, 1981, and you are at least 15 years old at the time you file your DACA, unless you are in removal proceedings or you have a final order. So let's break that down, okay? So born on or after June 1981, that new requirement means that there is a higher age cap for DACA. In the old rules, if you are 31 or younger, you can apply for DACA. If you are over 31, you can't apply for DACA. Now, under this new rule, that is raised up to 41. So 41 and under can apply for DACA. That's a lot more people, right? You might be 41 now, but maybe you came in here as a child. So like, how long ago was that? Maybe, more than 20 years, right? So a lot more people can now apply for DACA. And the second,
but it also mentions something about final order. So
right.
If the people have a deportation order, can they still apply for DACA?
Yes. So in the past, if you have a deportation order, you still have to abide by that 31-year-old limit, meaning if you are 31 or under, yes, you can. But if you're older than 31, you cannot. Now, under this new rule, if you have removal proceedings or a final order, it doesn't matter how old you are. There is no age limit. So you can apply for DACA regardless of your age. So again, that expands the number of people who can now apply for DACA.
Yes, and our office is going to continue update everyone on the newest immigration news. But if you want to discuss your own case, you should call in to make an appointment to see what kind of option you got for yourself.
Yeah, I mean, there are a lot of new rules that come out almost every month. In the past year, there were a lot of new rules. We only discussed a handful of them, and I think those are the most important ones. But there are also others, and if you've heard of something, you can obviously contact us and just keep following us so that you know all the latest news, because we do like to update people about developments in our immigration laws.
Or if you have more questions, you can feel free to leave your question with any of our platform.
Right, and aside from, like I said, aside from leaving questions, you can consult with us, and that really is the best way to get answers about your case, because in this YouTube show, even though I'm talking to you and I'm giving you my opinions and they're based on experience, it's not legal advice, and it's not advice specific to your case, and it's not legal representation. But if you have questions that you want legal advice on, and you want someone to represent you, you want us to represent you, then you can feel free to reach out to us and contact us through any of our platforms or contact information.
Yeah, you can continue follow us on YouTube. And thank you. See you next time.
Bye.